Kasi ano? Versus off. Okay. Sounds okay. Which one is 3? Yeah. They don't S there. Okay. But you can take
We are going to start the moment. Can we transfer the speech? We are ready. Please let those movements upstairs. And say please inside. Acabó de pena.
5.4 in the Procedure Act that the decision of the court are called may not be set aside unless justice was satisfied that the decision is wrong, in which case obviously it will hand down the decision that it regards as correct. Now, Justices, in our heads, we have set out the basis which we contend that the decision of the court of law is wrong. And we detail the matters in which we submit to the learned judge in the court of law, misdirected himself or committed grave errors of the law. However, before we deal with the merits of the appeal itself, there is the issue of the two judgments which we have raised in our levels of argument. I'm not going to be long on this issue, Justices, but may I submit that the issue looms large for several reasons. One is it is now formally before the court. The second is there is the principle of frontis officio applicable to judges who hand down judgments. And that principle was accepted by this court in the cargo case, which we've referred to in our heads, which followed what was said by the Appellate Division in South Africa in Firestone versus Jenipura. Now, Justices, in this case, we have pointed out that in two of the paragraphs, sections were added in what is the sign or the second judgment, which were not in the first judgment, and in addition, 3 paragraphs were added to the first judgment. The question, of course, in order for your lordships to make whatever decision your lordships make is, if your lordships dismiss the appeal, then the question is which judgment stands. And if not, then the question is which judgment is set aside. Now, we submit that in this case, the issue of additions to the judgment loom large for the following reason. The frontis officio principle would ordinarily apply. In the cargo case, Justice O'Regan said, well, having regard to what had been said by or the Appellate Division in State versus Wells in South Africa, there may be a more benign approach to determining whether to accept the supplementation of judgment. One thing we know is that in terms of the Firestone case and in terms of the common law, supplementation is not in regard to ancillary matters. It is regarding matters that are central to the judgment. In fact, it won't be unfair to the learned judge to say it would appear that the purpose of the supplementation was to reinforce the cogency of the judgment. But the second question is, in our heads, we make the point that the Constitutional Court in South Africa quite recently, in the tutor matter, dealt with the issue of a second judgment. And it said that in that regard, aside from what had been said in State versus Wells, one needs to introduce a constitutional dimension. That's because public trials, especially criminal trials, are supposed to be held in public. We, in our heads, said it is perhaps not necessary to introduce a dimension. On reflection, Justices, I would submit that in fact it is necessary because in making that submission we have overlooked what Article 12.1 of the Namibian Constitution says. If I could just read it out very quickly. It says, judgments in criminal cases shall be given in public except where the interests of justice or interests of juvenile persons or morals otherwise require. Now, the only question that would remain is this, was the bail hearing a criminal trial? We know it's not a criminal trial. But the question is that it's so closely related to the impending criminal trial that we submit a purposive interpretation of Article 12.1c requires that it be applied to this case. In that case, Justices, our submission is that the second judgment is, as was declared in the cargo case, the second judgment is a nullity. And we ask, as prayed for in our heads of argument, paragraph 80.1, that it be so declared, and that the first judgment is, in fact, the judgment that on which the appeal ought to be taken. Maybe make the point that in order to facilitate the processing of the appeal, we have accepted that in terms of the common law principle, the learned judge was entitled to have grammatical corrections or expressions introduced. And so we say that aside from the 5 paragraphs we refer to, which should be excised from the judgment, that should be the judgment that this court decides the appeal. Now, as regards the merits of the appeal itself, we...
Counsel, just excuse me. It seems to me that your complaint is essentially about some technical aspects of interfering with the first judgment, so to speak. I don't understand you to be arguing that the second judgment has materially altered in the sense that it has changed the outcome of the previous decision. Are we concerned here with the technical aspects, or are we concerned with the ultimate decision that resulted from what you term the supplementation of the judgment?
This is Mr. Joe, let me put the positions quite clearly. At one level, one can describe the additions as technical. Question arises at a broader level, and that's why I said, having introduced the issue, the decision is before this court. At what stage does one say that a judge may not, as you put it, interfere with a judgment which has been handed down? That's the first question. The second question is, where the public sits and a judgment is given, having regard to the provisions of Section 12.1c, is it a mere technicality to say that a judge may not supplement that? I would submit that the question really is the question supremacy of the Constitution and the doctrine of legality. If the Constitution doesn't permit it, then it cannot be done. Let me make this other point, Justice. And as I say, it may not materially affect the decision of the court. But let us say that a judge hands down judgment today, and the litigant on the losing side wants to appeal and starts preparing his application for leave. But before he does that, the judge augments his judgment to make it more cogent. The question really is that allowed in terms of the criminal law and having regard to the provisions of Article 12? And it is in that sense, though, when I accept that in this particular case it may be technical. The problem that court faces is, if it permits that, where is the red line that separates what is permissible from what is not permissible? That is why in the Tutor case, the majority said that even the latitude given in the Wells case ought not to be followed. It is the judgment that is handed down in public that must be the final judge. One final thing, the first judgment was not an extemporary judgment as traditionally understood, in the sense that it was handed down immediately or soon after argument. That judgment was handed down 10 days later. The second point, and this has not been disputed yet, that the judge had prepared a written judgment which he read into the record and finalizes everything by saying that's the judgment. That's all in the application. Those are the facts. And in no circumstances we say it may not be purely technical.
When you look at section 176 of the criminal procedure,
Yes.
to what extent do you need it to limit the time the judge can interfere?
Justice Shanghala'S, you will recall that in State versus Wells, it was said that account should be taken of section 176. Now, section 176 says a judgment may be corrected. What State versus Wells appears to do is draw a distinction between a supplementation of a judgment and a correction of the judgment. In my respectful submission, that is not good, because if you can't correct, then having regard to the common law, you ought not to be able to supplement. That is, but the Wells test has stood since 1990, and so and it was accepted by this court in the Cargill case. And so I do not want to go there, but I take the point you make. Now, as regards the merits, there are 4 broad issues I want to deal with. And the first is the basis on which the appearance sought bail and the basis on which it was imposed. Then the second one attributed to owners in this particular case, and why the decision of the learned judge in respect of owners is wrong, or is submitted as wrong. The third one is the approach adopted by the learned judge to the entire bearing on this judgment as a whole. And the last issue is the principal misdirections or material errors of the law. Now, as regards the question of the basis on which the application is made, it looms large because in this case, one has, in respect of the first three appellants, one has their affidavits. And the affidavits set out, both in factual form and in submissions, why they submit their candidates for that. They make the following points in regard to their application. Their main point is that at the time of their hearing, they had been in detention or in custody for some 2 years. They say, based on what had been said by Justice Mohammed as acting Judge Mohammed as the then one, in Atchison's case, that the provisions of 12(1)(b) of the Constitution had been triggered, and it is perhaps useful to read out what 12(1)(b) says. It appears under the general provisions of fair trial, and it says, a trial referred to in Article A shall take place within a reasonable time, failing which the accused shall be released. And we submit that being a provision in the Constitution, it needs to be interpreted properly in respect of all matters, and in the sense as was done by Justice Mohammed in the Atchison case. Now, the second point they make is that the first three pillars, the more serious charges that they are facing were investigated on the facts which were not disputed by the Anti-Corruption Commission. They say a proper interpretation of the provisions of the Anti-Corruption Act, together with the provisions of the Prevention of Organized Crime Act, precludes the ACC from investigating. So they say that to the extent that the allegation is made that they are facing serious charges, that allegation must be tempered by the notion that they may succeed in the criminal court in persuading the judge that the ACC investigations were unlawful, and accordingly those charges cannot be pursued against them. And their argument is based on the principle of legality. I will deal with that in a moment. If I could just ask you to keep in mind, in a sense, adopting what was said in Rally for Democracy by this court, and more recently in the Competition Commission case against Puma Energy, where this court, when it was asked to examine whether the Competition Commission or whether a particular official in the Competition Commission could apply for a warrant, said that having regard to the relevant provisions, although the Commission itself had the power to apply for a warrant, the official who applied was not entitled to, and it set aside the warrant and all the evidence obtained. And that's the principle or the doctrine of legality that is relied on. Then they say that there was evidence placed before the court in their affidavits which made reference to what had been said by the Prosecutor General in the restraint application. And that is a factor that should have been taken into account, namely that the IC had a drug problem, he had a mental problem, and more importantly, he was an accomplice, and on that basis was unlikely to come and testify. And to the extent that it's alleged that there is a strong case, this case is only as strong as the witnesses who would testify. If the main witness, and it was accepted by Mr. Cummings in evidence, if the main witness is not going to be there, that weakens its strength. Then they say that all their assets are subject to a restraint order, and they have no assets, and in a sense, if they absconded, then those assets would be lost. That is the consequence of the relevant provisions of poker. And then they finally say that it is unfair to require them to prepare for a criminal trial as massive as the one they are facing, whilst they are in detention, and that affects their right to a fair trial, which is protected by Article 12. And finally, the point that whilst they do not enter the merits of the case, they will be not guilty, they deny any wrongdoing, and they state on oath they will stand trial. One of the points they might is, in regard to the confidence that they have that they will not be convicted, is Pillars 1 and 2 were in Cape Town at the time that the arrest warrants had been issued. They were aware of those warrants. This evidence is not disputed. They returned to Cape Town, and the ACC arrested them after their return. All of this is not disputed. Now, in those circumstances, how can it be reasonably contended that they are a fraud? That's the case they have got. The opposition to the case was as follows: that the appellants face serious charges, there's a strong case, there's a fear that they will abscond, interfere with state witnesses, and in support of the strength of the case, the state referred to numerous documents which were presented to the court. Now, that's the first issue. The second issue I want to deal with is the question of ownership.
Before you proceed to the next issue, this issue about the authority of the investigating officer to carry out the investigations, in my opinion, it sounds like it is to say that the entire pieces of evidence he has collected is not admissible because he had no authority to investigate. Would that be the principle to conceptualize what you're saying? Because at the end of the day, what I don't understand is, to what does this lead to when you are concerned with an application for bail or release on bail? It's like you are saying the evidence is of no consequence, and therefore there is no strong case to be made, and as a result, the applicants have to be released on bail. Is that what you are saying in essence? No.
If you look at the affidavits of the applicants and their evidence, this is the essence of what we say. We are facing charges of corruption, we are facing charges of fraud, we are facing charges of racketeering, and we are facing charges of money laundering. Money laundering and racketeering are offences that are created by power. Section 83 of POSA says that an investigation in respect before any criminal proceedings or civil proceedings, the Inspector General must authorize a police officer to conduct the investigation. The ACC are not police officers. The ACC is a separate statutory institution.
What is the result? If your suggestion is correct, what is the result there?
The answer to that is, because they are entitled to investigate, the ACC and the investigating officer, is that how to investigate all the anti-corruption. And so all the evidence gathered in that respect will be admissible, both for the purposes of the bail application and the purposes of the criminal trial. It may well be that to the extent that fraud is related to that, it's also admissible in relation to fraud. But the evidence that he collects in terms of in respect of racketeering and money laundering is inadmissible because it does not have power. That is the submission. But there are 2 points that I must emphasize, and it's quite clear that the judge in the court of college didn't fully reach. That it was not a decision that he was asked to make, because he didn't have the jurisdiction. Because then there would be 2 decisions on it. When the criminal trial starts, that is the point at which the applicant will ask for a decisive ruling on that matter, on the lawfulness of the investigations into money laundering and racketeering. There are 2 possibilities. That court may say there is no substance in the point, we think it's one continuous investigation. Or it may say, on the basis of the doctrine of legality, which is a central value of the Constitution, you exceeded the bounds of your authority, and therefore, as has happened in the Puma Energy case, we ignore all of that evidence because it's not lawful. It would be no different in substance from if you obtain a confession from an accused person in circumstances not permissible in terms of the Constitution or in terms of the criminal procedure. So it's purely, but it's not a matter that we ask the learned judge in the court of law and careful consideration of our papers makes that. say that to the extent that the state says the accused, the appellants are facing counts of corruption, fraud, money laundering, and racketeering, leave out two. And so it reduces the seriousness of the case against you. That's the whole difference. But not to say that there is not a serious.
So what you are saying in essence is, you are saying the effect of the evidence collected by this unauthorized investigator is such that the accused are going to be confronted with evidence which is unlawful, which is illegal, and therefore this has the effect of saying that the case they are facing is not a serious case. Is that the net effect of the thing?
The number of charges they are facing, because the corruption would still be seen, that he accepts, but the number of charges that they are facing would be reduced if one
Severity.
Yes. Because that is a factor that is taken into account even on the basis of what is the nature of the charges. So if you are not facing charges of money laundering and racketeering, then the court needs to say, well, you're facing charges of corruption and fraud. Is that sufficient sufficient weight to outweigh all the factors I must consider involved? The issue of the onus is a matter that seems to really large in the judgment itself. Now, at paragraphs 50 and 50 to 52, we itemize the various instances where it is done. I just pointed out now to alert the justices to the importance that the onus played in this matter. For example, at paragraph 51, the judge says, an applicant for bail bears the specific onus to prove that the interest of justice permits his release. Then he says, this means an applicant must specifically make out his own case and not necessarily rely on the perceived strength or weakness of the state's case. If you look at paragraph, if you look at footnote 47, you will see the reference is to Shanghala'S case in South Africa. I'm going to come back to that in a moment. And then at paragraph 52, we note that the learned judge says, I've come to the conclusion that the appellants have not discharged the onus resting on them to demonstrate that their continued incarceration is a violation of their rights. And then he says, as to whether they will abscond or not, the scales are equally balanced, but because the onus rests on them, I can't rule in their favor. Now, there are two issues relating to the onus that I want to deal with. Perhaps I should just deal with the Matebula. Now, in his judgment State versus Lamini, which is referred to, unfortunately, he's not a judge that I include, but which is referred to in the Bowerset judgment. The case is State versus Lamini, is reported in 1999, volume 4, South African Law Reports, page 62B, Judgment of the Constitutional Court of South Africa. Now, Justice Crickler there was faced with the question whether Section 11 or Section 6011 of the Criminal Procedure Act was unconstitutional. Now, Section 60 of the South African Act, as is pointed out in detail by Justice Crickler in the Dlamini case, Section 60 has been amended to the point where, whilst the Namibian Section 60 has remained largely unchanged, doesn't deal with the question of owners and so on. In South Africa, the position has changed quite dramatically. Now, in what the value of the Dlamini judgment for us is the point made by Justice Crickler at paragraph 39 of his judgment. He makes the point that effectively the matters referred to by Justice Mohammed in Atchison's case, which is what the greater judge, I'm going to come to that point now, says he was following, that those matters represent a collation of the common law rules relating, or the common law and the case law rules relating to bail at the time the Atchison judgment. Now, that insight is contained, unfortunately, only in a footnote, but it appears at paragraph 39 of Justice Crickler's judgment. What is important about that is that several provisions of the South African, of the new South African Section 60 is largely a reproduction of the test that Justice Mohammed has laid down in Atchison's case. That's the first point I want to make. But the second point, and the reason I bring it up here is that the learned judge says, the learned judge in this case says, that the accused bears a specific onus to not rely on any weaknesses in the state's case. But that is a reflection of what Section 60, subsection 11A and B says. And that is why, there was a main reason why an application was made to declare that provision unlawful, because there was an onus that was now cast on the accused to leave evidence, to use specifically evidence. He needed to, if I could just, that's my easiest, just tell you exactly what it says. Says, notwithstanding any provision of this Act, where the accused is charged with an offence referred to in Schedule 6, there's the more serious charges set out in the CPA. The court shall order that the accused be detained in until he or she has been dealt with in accordance with law, unless the accused, having been given a reasonable opportunity to do so, induces evidence which satisfies the court that exceptional circumstances exist which in the interest of justice permit his or her release. That is section 6011A. Section 6011B deals with charges under Schedule 5. And instead of saying exceptional circumstances, simply says that the accused must satisfy the court that the interest of justice permits his release. Now, it is that provision which the learned judge in the court code relies on in relying on state constitutional. But that is not part of the Namibian law. Namibia doesn't have a provision which says the accused bears the onus. That has been part of the development of the law, and it was accepted recently that ordinarily the onus lies on the accused to satisfy the court that he is a good candidate. Now, the other two cases that the learned judge relies on in the paragraphs I have read are State versus Pinero and State versus Dowsett. That your lordship will find at footnote 46. Your lordship, Justice Frank, you appeared in you were presiding judge in Pinero, and I know it's a long time ago. But in that matter, having heard an urgent application for bail, Justice Frank, you ruled that the accused had discharged the onus of showing that they should be punished. But there is no analysis of where the onus lay, because the onus didn't matter. The next case, Justice Frank, in which question of bail arose, but in which you were also a judge of Justice O'Lynn, as he was at the time, was in the case of Duplessis. Now, in Duplessis, the issue was raised, as noted by Justice O'Lynn in his judgment, where the question was raised with counsel, but does not the new constitutional dispensation create a different basis to determine the question of onus? That court didn't deal with the matter because it said that in order to do so, it would require full argument which had not been given, had not been part of the application for leave to appeal, and the learned magistrate. So that question didn't. The only case where the issue of the onus arose is in the case of Dallas, State versus Dallas. And in that matter, Justice Hoff dealt with the issue. And we deal with that, Justices, in some detail. We deal with that at paragraph 56 of our heads of it's all set out there, but in essence, the point made in the heads may be summarized as follows. The matter was raised before Justice Hoff in Dowsett's case on the basis that Article 7 of the Namibian Constitution, which deals with the issue of liberty, required that there be an equality of arms, and the state, being the party opposing bail, should be the one who should start and should be the arms. The learned judge dismissed both those points. As to who should start, that's irrelevant for this purpose. In regard to holding that the accused was the owners, the learned judges, and with respect, it is a well-reasoned judgment on that issue. The learned judge compared the position in South Africa with the position in Namibia, having regard to the provisions I have read to you. And he said that the position in South Africa has been changed because Section 25 of the Constitution entitles an accused to bail unless the interest of justice take place. And so it was quite clear the way the owners lay. Then he made the point that Namibia does not have such a provision. And therefore, an accused being an applicant would need to be the owners. And there is nothing that was before him that made him decide there was something unfair about him. Except at this level, that he says that because Section 1611 of the Criminal Procedure Act in South Africa places the onus on the accused, and Justice Crickler in State v. Lamini had found that provision not to be unconstitutional. It was difficult to say that placing the onus, not a Section 1611 onus, but placing the general onus on an accused is not unconstitutional. That's the learned judge's reasoning. I'm perhaps not doing full justice to it, but it's set out for you. Now, we accept, for the purposes certainly of this appeal, that the learned judge properly applied the law insofar as ordinary cases of bail come before. In other words, an accused is charged, comes before a magistrate, before a high court, says, I want bail, and it's a period of 6 weeks or whatever from his arrest. He relies on the ordinary principles of bail. And those are, that is where the onus we submit would fall on the accused. Now you will recall that at the outset I made the point that it was important to understand the basis on which the appellants were applying. Now the appellants say, and that's right at the outset of the respective appellants, when I talk about appellants, it's obviously appellants 1, 2, 3. They say, we've been in custody for nearly 2 years. In terms of Section 12(1)(b), that is an unreasonable time, a reasonable time for the beginning of my trial continued detention is now unlawful because that's what Section 61B says. It says, a trial referred to in subarticle A shall take place within a reasonable time, failing which the accused shall be released. That's the provision on which they go. We submit that this is different from the position that pertained before Justice Hoff in Dowsett case, and it's different from the position that the court in State versus Duplessis was found. This is now asking the court to look at what are the implications where an accused relying on section Article 12(1)(b) comes to court and says, I have been in custody for nearly 2 years. 12(1)(b), the provisions of 12(1)(b) are strict, and therefore I ought to be released.
Isn't that to be something different? That's to be released on prosecution locally to the guidance. That's not to be released on bail or released on that. To be released in the story, they won't be any further prosecution. That's a specific constitutional right that you must try to enforce. A specific requirement. What I can understand is all the courts, that's also that the judgment and our judgment, it's all the courts of law that the duty to act constitutionally and to enhance the Constitution or to promote the objects of the Constitution. In that context, courts mustn't unduly postpone or easily postpone on behalf of the state and see that the trial gets going. But that release doesn't mean release on conditions. It's an unconditional release from prosecution for evidence. That's something else.
Justice let me make 2 points on it. Firstly, that provision was considered by Justice Mahoney. And the interpretation is the interpretation I have. I'm not saying your interpretation is wrong. I'm just saying that the interpretation accords with what Justice Mahoney said in State versus Atchison. But there is a second point, Justice Mahoney. And of course, comparisons in some sense are odious. In law, they are very instructive and useful. So if that is, now, I want to read, Justice Mahoney, to you what the South African Constitution says on this issue. Section 35, 3, and Section 35 of the Constitution deals with the arrested, detained, and accused person. Section 35(3) D says, every accused person has a right to a fair trial, which includes the right, paragraph D, to have their trial begin and conclude without reasonable delay. Now, the point I'm making is that the wording is quite different. And if one is talking about the trial, then the Namibian Constitution, one would think, would have said that the trial, the trial must be dismissed. And I'm just saying that I accept, and I've got to be frank with you, I've not, no comment.
In fact, one can expect that within
section that says you have to be placed before the court within a reasonable time. If he does not happen, the expectation is that then the accused person will move the court in order to seek to be released from prosecution because it has taken too long. And the anticipation there, in my view, seems to be that where there are reasons that justify delays, then an accused person cannot resort to that. But where the accused person is aware that no, there are no reasons for this, I don't see why I am languishing in jail, they will definitely file an application to ask the court and say, this prosecution should no longer be proceeded.
And then in that case, there is a way to interpret 12(1)(b) to give the accused two rights. One is to be released from detention, and the other is to be released from prosecution. And he can choose whichever one he wants. In Atchison's case, Atchison chose the 12(1)(b) amplified with Article 7. And that's exactly what the accused have chosen. So Justice Friend, may I respond in a slightly different way? That's not the case with me. If that is the case, the issue really is, can an accused not seek less relief than the wider relief that your interpretation? In other words, the prosecution must be, of course, if the prosecution is stopped by this court, the accused must walk away today.
Which should be necessarily not the road.
But that's exactly, but they bring the bail application by relying on the right in terms of 12(1)(b).
I mean, the prejudice just to the accused has always been a factor. In time, that's what is outside Muhammad. But the problem, we're talking in a different context, and we're talking in the onus context. If you want to use 12(1)(b) to put onus on the state.
Yes. It's
The other way would be in the general plea consideration where the accused has an onus. That's one of the considerations you must take into account.
And that is why I try to distinguish the reasoning in State versus Dawson and accept that given the case that the learned judge, as he then was confronted with, namely Article 7 guards protects my liberty. Therefore, the onus is on the state. But where an accused now comes in, and of course, Article 7 says a person is protected from arbitrary arrest unless sanctioned by law. Now, the sanctioned by law obviously must be read in context, because a person is arrested on the basis of a warrant, is brought to court, is charged. He now, 2 years later, says, but this is on the basis of what is contained in Article 12(1)(b), I am entitled to apply for bail on that basis. If you choose to oppose bail, you show the court why my 12(1)(b) right does not trump your right to keep me in custody.
I understand.
And that is why, right at the outset, I made the point that the case is based on trust. And it is, when one looks at the case that was made out in court, it is based squarely on what happened in State versus Hutchison. Squarely on that. The accusers, except for one difference. In Hutchison, he had applied for bail, refusal confirmed by the High Court, and then when he was arraigned before the High Court, he then applied for bail again, and one of the questions was, well, you can't do that, and Justice Martin says, never mind. But that is when he dealt with this. Now, can I just ask him, I don't want you, and I accept, Justice Frank, that you've read the heads and clearly based on the interchanges, all of the justices have. But I just want to make the point that at paragraph 58 of our heads, we make the point right in the middle that the court in Dowsett did not consider whether the right of an accused who is not tried within a reasonable time required that the question of where the onus lay in such cases needed to be examined. It is submitted that it needs to be. And that is where we say one of the issues that arise in this case. Because if the onus issue must loom large in this case, because, as I have pointed out, the learned judge placed so much of emphasis on onus. But then this is what we said. I just want to make sure that I make the point properly. Article 12 provides, 12.1b provides, a criminal trial must take place within a reasonable time, failing which the accused shall be released. And the question whether from prosecution or from custody, the submission is given in the purpose of interpretation, one would say perhaps wrong, but certainly can't exclude them. Then we submit that based on the interpretation given in State versus Atchison, the right in 12.1b reinforces the right in 12.1, the right in Article 7 to liberty. And the point we make in this case is that ordinarily the onus would lie, as found in Dowsett, ordinarily the onus lies with the accused. However, the effect of 12.1b is to limit to a reasonable time the lawfulness of the deprivation of liberty that Article 7 permits. Article 7 says, provided it's in accordance with law. The further submission is that the combined effect of Article 7 and 12.1b is as follows. A person suspected of committing an offence may be arrested in accordance with law. He or she may be kept in custody, pending the trial, subject to his or her right to apply for bail, not to be released as in South Africa, but to apply for bail in terms of Section 60. Should he apply before a reasonable time has passed, the burden rests on him. However, after a reasonable time has passed, then, given the fact that the 12.1b is emphatic, the accused shall be released, we submit that if you want to avoid that consequence, the state wants to avoid that consequence, it bears the onus of justifying continuing. just make one final point on that score, because that's what was said in housing, and we accept the reason in housing. That the Article 12.1b right to be released after the passage of a reasonable time has passed is no different from the right in Section 25(2)d of the South African Interim Constitution or 35(1)f of the Final Constitution, or Section 60 or 60 subsection 1 of the Criminal Procedure Act. And so it would be that the onus ought to be on the state. We make the following further points in support of this. In 1D, which is a paragraph 60 of our legislation, this court said, the whole tenor of Chapter 3 and the influence upon it of international human rights instruments from which many of its provisions were derived call for a generous and purposive interpretation that avoids the austerity of tabulated legals. So we say that ought to apply to the right to 12.1b, where would the right to 12.1b? And then, of course, what was said in Atchison, which we quote in paragraph 61, says the Constitution of a nation is not simply a statute mechanically defining the structures of government and relations between the government and the government. Then it says the spirit and tenor of the Constitution must preside over and permeate the processes and judicial interpretation and judicial discretion. And this is the point I want to emphasize. The learned judge in the court of law extensively from this. But this passage it does not quote. And the relevance, I don't think it did it deliberately. But the relevance of that is that in considering the appellant's bail application, he was required to exercise discretion, and as he set out so firmly in Atchison's case, that discretion ought to have been permeated by the spirit and tenor of the provisions in the Constitution.
Sense of justice or sense of people must be able to account for their work or their crimes, etc., etc.
Just Frank, I've got no difficulty with that. The difficulty in this case is that effectively, and that's the next issue I want to deal with, effectively, there hasn't been that in the judgment. And we accept that it's not only the rights. That's the point that was made in the due procedure. We accept that. But the beauty of the due procedure judgment, and Justice Frank, I must say this with respect, is when it was not even raised, your bench raised it. But of course, because it couldn't be dealt with, the only point I'm trying to make is that one can't compartmentalize rights. The rights are part of a broader scheme of allowing society to continue its democracy in a meaningful way. That can't be done unless those who are guilty of crimes are brought to book. Question really is, this really is the nub of this case. In granting the evidence bail, one is not saying they are not guilty. One merely says that the Constitution says in order to retain a person in custody, these are the conditions that must be fulfilled. We say that hasn't happened. Now, when I come to Justice Frank, I sort of hesitated when I gave my answer to the start of the judgment. And that's because of the next topic that I want to deal with, the general approach adopted by the administration. May I ask Justices, I can just ask that you have the judgment in front of you. Because I want to go through the scheme of how the learned judge deals with it. He starts off with the quote from Hutchison, which says that an accused can't be kept in detention until, as a form of anticipation, it's volume 26, very last. Fortunately, the premise is page 4, where the introduction, where the code for yes. Then at paragraph 10.
Sorry, I want to page TC with 2,900.
Or 3004.
I've got volume 25. I've got that judgment. And
I want to refer to the paragraph. It's right at the top.
the judgment starts at 2903, it's in volume 25, it's the same as the
Yes.
probably two copies. First paragraph, the accused person cannot be
Yes, but I just want to emphasize that. Then at paragraph 10, the learned judge quotes the matters or says that in deciding the question of bail, these are the considerations that must be taken into account. Now, I'm ignoring now, because I've dealt with it and I don't want to step on time, the question of onus. I've dealt with the question of onus and I say wherever the judge says, the learned judge says that the onus rests on the accused, we submit in this case is wrong. Then, but what he does say is, these are the considerations that Justice Muhammad outlined and sets out the three matters, namely, will he abscond, will he interfere with the witnesses or the investigation, and what is the prejudice to the accused. Then paragraph 12, the learned judge says, having set out the legal principles, I turn to consider the grounds on which each applicant seeks bail. And then from paragraphs 15 to 46, just setting out the grounds. Then he sets out from paragraphs 47 to 60. the basis of the opposition. Then, from paragraph 61, there is the heading discussion. Now, as far as the discussion goes, the learned judge then says, having set out the case of the applicants say their constitutional rights have been violated. And then he sets out how one goes about proving that the right has been violated. That's at 62 to 66. And then he quotes concerns raised by the court in Duplessis about simply taking matters of the Constitution out of context. But as I say, that those remarks must be dealt with on the basis that the court itself in Duplessis had raised constitutional issues. It just didn't deal with it. And the submission is that that is the balancing act that is required. The rights of the accused and as against the interests of society. That is exactly what Justice Mohammed says in Atchison's case. Ordinarily, an accused should be released on bail unless it is against the interests of justice and you look at the following considerations. Now, I want to deal now with how the learned judge, having articulated what Justice Mohammed said were the considerations, he says that from paragraph 68, for the reasons I have set out, I have come to the conclusions that the applicants have not discharged. And then continues as to why that is so. Then he deals with the question of the ACC and the issue that was raised earlier and by Justice Masutu, namely, but where does that get you? The point I was making, and I repeat, is that if the ACC is not allowed to investigate money laundering and racketeering, then those counts may not be taken into account in the determination. But of course, and I have to make this concession, this court cannot make the decision, the matter is not before you. But if you come to the conclusion that within the judge and the court are cold, decision is wrong, then we ask you, in taking, in deciding what the correct decision is, you have regard to the fact that maybe the decision of the trial of the criminal trial will be. Then the learned judge, then from paragraph 74 and 75, says, deals with the question of whether they have means to escape and so on, and says, in my view, the scales as to whether they will abscond or not are equally balanced and can't be determined. But because the honest rests on the accused, I must find against the accused. And then at paragraph 77 to 80, he merely sets out the various allegations made. And then he says, paragraph 81. What are the factors that the court must take into account in determining whether an applicant is likely to interfere or tamper with evidence is whether or not a condition preventing communication between them can effectively be released.
That's what the complaint. Isn't that one of the paragraphs?
That's one of the paragraphs. It says, the state led testimony that Mrs. Shanghala'S and Lupi were on 2 different occasions found with mobile telephones. I ask you, Justices, to consider the quantum leap made between having telephones, cellular phones, in a prison setting and interfering with state witnesses. Or you may say that, but I'm not sure they will comply with all this. But that leap between the possession of cellular phones and the interference with state witnesses and the interference with state witnesses and the investigation is a problem. There is a second problem with the whole approach of the The evidence of Mr. Kanyandela was clear. The investigations are over. We are ready to start trial. What interference can there be?
What people can show the evidence that the government rules and usually do them. And on the bit here, if you get something there, that's it. I mean, surely we've been in criminal trials a long time. It's not even a witness who speaks peace with witness statement, no data. Just forget something that is very crucial. That's something that you forgot to tell the investigation officer or a document that you had now.
But on that basis, on that basis, Justice Kanyandela, no issue should be released. Because they're possible. I mean, and that's precisely why Atchison sets out those considerations, and they are so powerful, they've been incorporated into the statutory provisions of a neighboring country. But when it originates here, it is not applied by a judge who is bound to apply it and says he is applied. That is the essence of the convention.
What you now just mentioned is also a mistake in terms of the discussion together.
Now, the judge also then uses the inequality asked by quoting the Quran. Then he says, but one size can't fit all. Well, what does that mean? It's exactly what he says. At paragraph 84, while the sentiments expressed by Justice Ndaka accord with the principles of constitutional democracy, one must not forget that life is never a one-shoe-fits-all sizes. But surely, that is what a proper application of what was said in Atchison required another judge to do. And so, when one looks at the judgment as a whole, the entire approach, there is no analysis, there is no weighing up of facts, and yet the learned judge deprives people of their liberty on the basis of merely a iteration of facts. That can't be what the judicial officer asked to decide an important question like this. I have 5 more minutes, so I'm going to stick to it. Now, may I then say that given rejected that approach. We say the entire approach constitutes a misdirection. It is not what is required by Atchison. It is not what the learned judge said he was going to do. And in those circumstances, there is no basis to hold the decision as correct for the reasons he has given. There may be different reasons, but that's a different question. Now, I have dealt with the question of onus, dealt with the question of the approach of the learned judge. Now I want to deal with specific items. I'm just going to itemize them. Firstly, the learned judge says, and I read that passage where he says, in Condo's case, this is what I'm saying. In Condo's case, dealt with, and we've said it out in dealt with a challenge to the constitutionality of a statutory provision. Now, in Atchison, Justice Muhammad says, 7 months, 12(1)(b), your right to liberty, presumption of innocence, things we're arguing, said, and you'll see that in the argument, said, but these accused of being in detention for 27 months, is that fair? But in his judgment, he says, but you haven't proved it. The question is, what type of proof does one say that where a judge of the stature of Muhammad, has found that 7 months is a judge? How does one say that you must, there are secondary facts that constitutes misconduct? One of the factors that was raised throughout was the reliance that can be placed on this man. Now, the judge at various points said, Mr. Kennedy, can you walk? I said, do you walk? Do you go to church? And the purpose of those questions was simply answer the question. Because that was the type of witness. And there were many times where he was accused, by me obviously, of being disingenuous. But it's all there on the record. Now, there is not a mention in the judgment, because that's dealing with the state. But you know, it's coming here, they didn't make best of the Or, why, notwithstanding, he relies on him. Here is the way Mr. Kangangela conducted himself. He is told by the Icelandic defendants, we say to you that Stephenson won't come and testify. He doesn't investigate. Not at all, he comes to court. The question really is, surely that deserves a mention when one is looking at the overall picture. And when one is depriving persons of fundamental rights like liberty, one needs to say that can only be on the word of somebody whose evidence is credible. We conclusions that justice is right. Based on what is contained in our heads and the past that we will be taken into account on account of fact and on account of what I've said to you. Also in answer to Christians, we ask that it be found set very strict conditions on close-up.